Good afternoon. My name is Chris Roebling, and I have the privilege of acting as moderator today for the Union League Club of Chicago as part of its 140-year tradition of commitment to community and country. We've got co-sponsors for this afternoon's program, which include the Standard Club, our friends located very close to the Union League Club. It's a privilege to have all of you involved and to join me in welcoming our speaker, Judge Pat O'Brien, who is the Republican candidate for State's Attorney of Cook County. We've got a tradition that goes back to 1879 at the club that we start our functions with the Pledge of Allegiance. That's been getting a little updated interpretation in the Zoom era. So I'm going to stay seated, but start by saying, I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Pat O'Brien's led a life in the law, and it's been dedicated to bringing justice to the realms in which he's operated, principally the Cook County State's Attorney's Office, where he became a felony prosecutor, and the Circuit Court of Cook County. It's a delight to inform our members, both in terms of the folks who are here today and the folks who will see this on our website and through links about Pat O'Brien's background. And so, Judge O'Brien, I'd like to structure today this way. How about if you take 20, 25 minutes or 15, whatever you want, to talk about your interest in the job, your stump speech, and then we'll open it up to questions. So all of you attendees, there are chat functions here at Zoom. You can send me your questions, and I'm going to put them together and give them to Judge O'Brien in the second half of the program. So with that understood, Judge O'Brien, Notre Dame law grad, the floor is yours.
Well, good morning, Chris, and to the members of the Union League Club of Chicago, good morning to you. I appreciate the opportunity to be able to speak with all of you today. And if I might, I had been saying on the stump that if I talk more than 2 minutes, every minute after that, I'd lose a vote. But I'll take that and put that aside for the moment, because I think it's appropriate to give as much, information about myself and about what I think are the office needs and problems. So hopefully I won't lose those additional voters as I go over the 2-minute mark. First of all, I've been practicing law, licensed in Illinois for the past 45 years. As Chris indicated, I was in the State's Attorney's Office on 2 different occasions. First time from 1975 to 1981, where I started with appeals and went through the various units in the office until getting to the trial courts. In 1981, I left the office and went into the Illinois Attorney General's office, where I stayed there for 5 years. And I would travel around the state and assist other state's attorneys where they may not have seen violent crime for decades. I learned a lot about the state. I learned a lot, it was almost a graduate course in how to practice law, because none of the kinds of supports that I had in the Cook County State's Attorney's Office, in terms of other assistants who had more experience, judges that you were used to, procedures that seemed to be custom and habit, all of that went away. And I had to learn a whole new set of how to see other counties, see other judges, etc. And it was a graduate learning experience. I got married in '85, and it became necessary for me to stop traveling around if I wanted to stay married. So I asked to go back to the state's attorney's office, and the first assistant was nice enough to ask the then state's attorney Daly if I could return. I did return. I had a number of supervisory positions from there, deputy in felony review, felony trial supervisor, and then head of the General Criminal Bureau, and finally, head of all the criminal prosecutors in the office. So at the time I left, I would have headed probably 750 assistant state's attorneys. And while doing that, I still tried cases and learned a great deal from all of the four state's attorney that I served under. Potentially how to see the office, how hopefully to execute policy when you might be some 4 or 5 levels of supervisor away from the persons who actually implemented that policy. After leaving the office, I went into private practice, where I practiced criminal defense for the most part and remained there for about 13 years. And I saw a lot of the kinds of things from that side of the courtroom that I think helped me broaden my understanding of the criminal justice process. A lot of times you wouldn't be successful in the cases and clients you represented, and you had to comfort the mothers and fathers and family members when their son or daughter ended up being found guilty or pleading guilty and going away into the Illinois State Department of Corrections. So I think I learned how to see the system from the other side. And again, it kind of broadened my view of what the state's attorney's office in criminal prosecution meant. In 2006, I ran for judge as a Democrat and won. I then served on the bench for 8 years, 4 years in the criminal side with assignments in traffic court, misdemeanor court, I guess preliminary hearings. And I then was moved to the civil side of the courtroom, where I learned a criminal, I should say, civil code of civil procedure, which wasn't all that familiar to me. And I did 4 years handling civil cases where there was torts or contracts, and eventually the last 2 years, collections, where people that got judgments and were having difficulty in obviously collecting from the plaintiffs, I'd see them in a courtroom. And I also saw attorneys who had felt they were owed money by their clients, and I would see them in the courtroom. And every time an attorney representing a claim came in front of me, I noticed that they looked down on the client or former client and looked to see what kind of wristwatch they were wearing. And I think part of that was to see if that was suitable to take for collection. So I learned a lot about being a judge, about human behavior. I've occupied every one of the 3 seats in a courtroom that you'd want to, from prosecutor to defense attorney to a judge, and the one that you never wanted to be in, which was a defendant. And at some point in time, back in 2019, when Kim Foxx made her decision to drop the Smollett case, I was astounded and felt that I had to look more closely to see if an office that I grew up in, learned how to be a lawyer in, could function in a way that I still felt was appropriate. And looking at that office, I came to the conclusion that it wasn't functioning as it should, and I decided to run. And that was about 18 months ago, I guess. The state's attorney is in a position that's unique in the county. They are the chief criminal law enforcement officer in the county, which means that both misdemeanors and felonies, if they're going to be approved and are going to be handled by anyone, it's got to be the state's attorney and his or her assistants. And if the state's attorney decides not to charge, that case typically will not go forward. The state's attorney, after charging, decides to dismiss the case, that prosecution ends. And if the state's attorney, having decided to charge, doesn't understand that people, while they're waiting trial, have to be, I guess, look to see if we're obeying their particular conditions of bond or electronic monitoring. And if they're not, you have a responsibility to bring that before the judge so that some action can be taken to make sure that they're not committing more crimes while they're out on bond for a crime. And then finally, the disposition itself. Now, having been in the courtrooms and seen from all three positions how the system works when it works best, there's got to be activity level at trials. You can't just plead cases and not try them and think that you're going to make the community safer and give a voice to victims. You've got to be active in trying cases. And in the office when I was there in the late 80s and early 90s, we averaged about 450 trials, jury trials, across those 50 courtrooms, and then another 3,500 or 4,000 bench trials. And the reason why that activity level is important is because it drives the rest of the call. Back in the 80s and 90s, we would average about 38,000 to 40,000 dispositions in a year. Now, as you can see from the numbers of trials that I related, it's probably 10 to 12% of the dispositions are by trial. But it's that number of dispositions and the success you have that basically allows you, when persons are looking because of the odds are stacked against them, to plead guilty, to get a disposition which is appropriate. Now, in 2019, when I looked at the disposition rates for the state's attorney's office, in 2019, across 50 felony courtrooms, that office tried 170 jury trials. So about 35 to 40% of what the number that would have been tried back when I was there. And they lost 1 out of the 3 jury trials. Now, to give you an idea why that becomes important, and all the practicing lawyers probably have a great understanding of this. In federal court, when you're charged as a defendant, and I've practiced in federal court, not a great deal, but enough. Sometimes you feel like you're a pallbearer for the living. You're just basically walking your client to get the best deal on a plea because they win 90 to 95% of the cases that they charge on the criminal side. So if you're only winning 64 or 65% of your juries while you're in state court, you're going to have a lot of people who are not looking to plead, or if they're looking to plead, they think they've got you over a barrel and are looking to get a reducer or some sort of agreement, which quite frankly doesn't favor the safety of the community. So there's a reason why you need that activity. Now, violent crime is such that it has a couple of different, if you will, I guess, layers where it affects people. Obviously, the victim of violent crime has the most, I guess, critical and significant impact by the crime itself. But there are succeeding ripples in that. And if people don't feel that violent crime is being effectively prosecuted, the fear that that generates in people that are not victims affects their daily lives. And I think we've seen not just COVID as affecting people's behavior, but I think we've seen the fear of violent crime, which seems to be scattered not just in certain parts of the city, but in every part of the city and into the suburbs. It makes people less likely to come down into the city, less likely to use the kinds of entertainment and variety of museums that we have. The activity level, which generates the economic taxes and base, less likely to actually support the city and the residents as we try to get better housing, education, jobs. So and it also affects even a wider circle, which is those persons who from other states or other parts of our state now don't feel safe to come into the city, to stay there for a time, to see our shows, to see our museums, to see the great architecture that we have. And it affects us internationally. if Chicago once again is seen as, the kind of place associated with, as it was in the 20s and 30s with Al Capone, only this case with gangs, we're going to fail to get those people to decide to either stay for a week or to come to visit as they're going through other cities across our nation. And again, of course, that economically affects us. So we've got to have not just a reduction in violent crime because of the victims who suffer from it, but all of the people who fear it. And at this point in time, that's not occurring. We've got a situation where the state's attorney, I think, has failed to recognize how devastating an impact the looting and rioting had on the two different weekends where it occurred in this year. She was quoted, I should say, and said in a press interview on May 31st of this year that she only became aware of the rioting and came downtown when she was awoken to see it on the news. That she hadn't been downtown in her office since March 18th. The state's attorney is not a bystander. If the state's attorney isn't active and proactive, then obviously there's no one that has the authority to make the kind of decisions on charging and on the kinds of decisions as to whether people who are charged but not in a jail setting, if they're behaving. And this state's attorney sees herself as a bystander. She sees defendants and offenders who commit crime as a second victim. Somehow their circumstances and how they grow up and if they're poverty or if they're African American or Hispanic, that is more essential to her charging decisions than whether people where they've committed crimes and there's evidence of that should be held accountable or responsible for those crimes. This occurs in nonviolent crimes, not just in the violent crimes. State's attorney has decided that despite the level that the legislators have set for retail theft at 300, she's decided on her own to make the level $1,000 and more before she charges a felony. She's decided that narcotics, and I'm not speaking about cannabis, which under the new law in terms of possession is no longer an offense. I'm talking about hard drugs. She's disbanded the Narcotics Prosecution Bureau, and narcotics cases, when arrests occur by the police departments, whether in the city and the suburbs, those cases, when they come into court, are being dismissed out of hand. She has, and I think it's been publicized, and I've got a commercial to publicize it. In her 3.5 years as state's attorney, she has dismissed 25,000 felony cases, which is 30 or 40% more than her predecessor in the same amount of time. And this kind of rate of dismissal sends a message to the gangs that support themselves by selling drugs and support the areas where they sell drugs by arming themselves to make sure that nobody else effectively comes in and takes their economic purse away from them. So the state's attorney has a very unrealistic view of what her job is and how human behavior is. I think she feels that by ignoring violent crime, it goes down. And I think we've seen in 2020 the exact opposite, which doesn't surprise me in I suppose, a human nature perspective. It's just not the way behavior works. If you ignore something that's wrong, it typically doesn't tend to go away by the person who has committed that wrong. They just feel empowered to do more. So I think we have to put a more of a common sense view of human behavior and also more of a proactive and active sense of what the state's attorney's job is and how it can be performed. And the state's attorney doesn't just prosecute violent crime and prosecute offenders in financial crime. they also have a duty to basically divert people out of the system who commit low-level crimes and also have little or no background. And that job has been done and been seen by state's attorneys back, certainly in my experience, since the middle 70s. This isn't new, but for this state's attorney, it seems that's the only function she sees for her job and for her duties. And that's been the problem. You've got to examine crime. You've got to see that violent crime and criminals are prosecuted. You've got to make sure that people who are appropriate get a second chance and hopefully don't come back into the system. And where there have been convictions, you have to see that based upon new technologies like DNA, which wasn't available before. You've got to see that those convictions have DNA testing available. And if it turns out that the conviction was inappropriate because new DNA says it is, then of course you've got to make sure those cases the convictions get vacated and the offenders obviously are released from prison. The state's attorney has to understand that this COVID virus that we see now, and which seems to potentially have, again, a second wave, if you will, that it's not going to go away on the first of the year. And she's got, or I'm thinking that I've got to prepare this criminal justice system in Cook County for COVID, which means that you've got to prepare courtrooms to effectively and efficiently make jurors feel safe so that you can have jury trials. Because there's going to be a wave of defendants, that most of whom are represented by public defenders, who are going to not want to wait much longer to get some kind of disposition in their case. It's not something that I see this state's attorney doing, and I think unless there's a change, unless I'm elected, she still won't do it. And the kind of pressure that'll be put on the system will be the kind of pressure to reduce charges, to dismiss cases, to make it more dangerous for all of us. So I think that as a state's attorney, I can effectively address violent crime, put in a gang unit that addresses guns and drugs, get a multiple or separate grand juries seated to investigate murders that have not been solved. Chicago police presently are solving homicides at the rate of 21 or 22%. So 4 out of 5 people that are murdered, there's no one that's been arrested for those crimes. And part of that reason is because witnesses don't feel safe. I'm proposing a witness protection or relocation program, which effectively gives witnesses the ability to come forward, which places them outside of the community where their gangs are entrenched, gives them job opportunities, schools for their children, effectively counseling where it's needed because of the disruption of their lives, and gets the shooters in these gangs in custody in the Department of Corrections where they belong, and not on the street keeping everyone prisoners in their homes. I think we need a public corruption unit which effectively prosecutes public officials. This state's attorney obviously was put in office by Tony Preckwinkle. The county has more elected Democratic officials than certainly Republican officials. The federal government does a good job in trying to root out public corruption. But if they were totally successful, we wouldn't see every couple of years all of these indictments and investigations. The Cook County State's Attorney has to step up and be a partner with the federal government. I think that there has to be a push in the legislature. We've got a RICO statute, which effectively allows us to have overhears on conversations where there's criminal activity. But it doesn't allow us to do that without the consent of one of the parties in the 2 crimes that are most likely to be the crimes committed by public officials: official misconduct and bribery. We have got to amend our statute on the overhear to include those crimes. And I know the legislators don't want to see that, but I think with a public push, we've got to make it known to the electorate that there is a need for this. And if your public elected official doesn't want it, you've got to ask them why. And maybe they shouldn't be in office if somehow they want to protect themselves from possible investigation and prosecution, not just by the federal government, but by the county government. So I think there are programs to be put in place. There is a reasonable and effective law enforcement that can be done and view both people that you want to get outside the system and violent criminals that you want to put in jail. And that's effectively what I hope to bring to this. And as we vote, I hope that your members consider voting for me. And I think I've gone far over my 2 minutes and hopefully have put enough out there so that if people have questions, Chris, I'd be delighted to try to answer.
Pat, that's terrific. Thank you very much. I really appreciate your remarks. And I do want to say to everybody attending that we have invited State's Attorney Fox. She has accepted. She will be here tomorrow at this very same time, and we'll be having this conversation with her. We also had Mark Curran, who is the Republican candidate for United States Senator, on a few days ago. We have invited Senator Dick Durbin, and I believe that his office is still trying to fit our request into his Senate schedule. So we'll see if that conversation comes about. But in the meantime, very much appreciate, Judge O'Brien, your comments. And yes, there are questions. Former retired professor Corinne Morrissey, and club member, asks, what is your position regarding the appropriate level for bond amounts?
The new bond or bail statute came in a little over a year ago, and it attempted to take out the question of economic status from whether a person should be held in custody or not. And they use the term affordable bond. I'm in favor of certainly not having people wait in jail if they're been charged with financial crimes. I am, however, in favor of considering all of the kinds of considerations that the bond statute calls for where we have violent criminals. And that's the nature of the crime, the background of the person committing the crime, the question of whether there is danger of them not coming back to court, whether they're a threat or danger to the public. Part of what we've seen is that on gun offenses, which the couple that have mandatory prison sentences, if in fact there's a conviction, the persons that are being placed either on low bonds or on electronic monitoring are reoffending. So I'm in favor of bonds that consider a person's background and those other factors. But I'm also in favor, if the person's going to be on electronic monitoring, that there be a GPS component. Right now, electronic monitoring, and there's 3,500 people in Cook County on that. And it's a program monitored at any one time and shift by the sheriff's office by 20 sheriffs. Imagine with 20 sheriffs trying to keep tabs on 3,500 people. And the only place where they are being monitored is the residence that is listed as the place from which they're supposed to be home. You've got a number of different situations where you can be outside that residence without offending or having committed any violation of your monitoring. That's school, work, looking for work, medical. So you can have persons on electronic monitoring with multiple hours where they can do these activities. And being outside, they're not effectively being outside of what is appropriate. But there is no way to know without GPS whether they're going to school, whether they're looking for work or at a job, or whether they're at seeking medical attention or at a doctor's office. So we've got to have that GPS component. And I would be in favor of that. It's going to add a little more money. But the whole point of expanding electronic monitoring was to reduce the amount of money that the county spends on housing people. So I think we've got to spend a little bit more on getting a GPS component. So I'm not in favor of holding people in custody on low-level financial crimes. Violent crimes where those other factors are involved, danger to the public, failure potentially to appear in court, background. I am effectively saying that they should have a cash bond that's appropriate. And I'm in favor of getting people to trial quicker. You know, I've seen stories in the paper where there's something like 500 people who are waiting trial in Cook County for more than 3 years. That's really unacceptable. I think, and that's what I've spoken about in activity level. You've got to try more cases. You've got to get people to trial quicker, and effectively that'll lessen the number of people who've been in jail for periods of time that are, quite frankly, unacceptable.
Thank you, Judge O'Brien. Pat, let's see. Our member R.D. Yant, who's a practicing attorney, has two questions. One is historical and the other is policy. His policy question is, do you feel that after the crime reforms of the 1990s, too many people were going to jail and then to prison? And the historical question, can you please recite your sort of interpretation of the state's attorney's office's involvement in the Burge case, John Burge police torture case?
Okay. As a policy question, were too many people going to prison? Clearly, there was a lot of prosecution of marijuana offenses, and people might be put on probation for a possession case or possession with intent case, and then they reoffend and the probation had turned into a prison sentence. And obviously, the public has now taken appropriately through the legislators a different view on marijuana. So I think some of the persons that were affected by the prison population affected by the marijuana, that's changed. And that wasn't something the state's attorney put into effect in terms of the 90s. That was simply following the law. I guess we've taken a more enlightened view, and I'm in favor of that enlightened view. You really don't want people in jail who shouldn't be there or don't need to be there. So I'm in favor of that. But I will note, in terms of people that were in IDOC or in prison in the 90s, the number of homicides from about 1985 or 6 up and through 1995 were astounding. They were averaging something like, in the city alone, 850 homicides. So you had a lot more violent crime that was going on. And you also had a high, rate of solving those crimes. In Chicago alone, their average rate for solving the homicides in that same period was over 70%. And as I indicated, the solve rate in 2019 was like 21 or 22%. So some of the increased prison population was accounted for by the increased number of homicides that were occurring in each of those, that's almost 10 years. And it was further, occurring because there were more cases that were homicides that were being solved. And certainly you would have more people if they were solving those crimes and if the persons were convicted going into prison. So some of the population increase in prison was because of the increased violent crimes and homicides. Some of it was because of marijuana cases, and quite frankly, it's something the legislature had there, the public felt was appropriate. I think we've come to see that obviously it's not appropriate. The legislators the public has said through their legislators that it's not appropriate. So that's being done away with. And I think in terms of policy, the state's attorney has to enforce the law. So it's something in the 90s that was there, and I don't know that the state's attorney, the elected officials could turn their backs on it. People feel differently about it now. I'm in line with what is there and what that the legislature now and the statutes now show. So I'm perfectly fine with it, and it's not going to change under me, as long as the public feels that marijuana is not something that people should go to jail for. I'm in agreement with it. The point of the state's attorney is to enforce the law. Now, and that's what I will do. Now, with regard to the Burge cases, John Burge has been shown, certainly in federal court, to have lied about torture. I never prosecuted personally any case that the detectives under Burge would have, I guess, taken statements on. Clearly, and I was out of the office, it's not a defense, but from 1981 to 1986, or part of 86, I wasn't even in the state's attorney's office. A lot of those cases that occurred were occurring during that time. Obviously, you don't want to put the wrong people in jail. You can't violate people's rights by having excessive force or threats used to gain statements. Clearly, those cases where there were statements taken and where excessive force and threats were used and people went to jail, those people should be out of jail. And quite frankly, now everybody is, the integrity unit that exists, and it was put into place under State's Attorney Devine in 2007. That unit needs to be kept. It needs to be effective. It needs, to review cases where there are new technologies such as DNA, or where there's allegations of excessive force which produced unconstitutional evidence, which may have been part of a trial. That unit's going to be there. It's going to be stronger. I'm going to push for more funding for DNA, because there are a lot of people in the penitentiary who are requesting DNA testing where it's delayed for a year or more, simply because there aren't enough forensic scientists that the state has working for them to do these testing. So I'm going to push that the state increase the number of forensic scientists to get the DNA backlog out, both for people in prison system, for cases that are pending, for cases where there's been rape kits taken, but nobody arrested. All those three situations, you've got to get the DNA done. It'll solve cases. If there are people in prison that shouldn't be there, it'll get those people out of prison.
I got stuck on mute. I apologize. Your Honor, we have a question from Jonathan Arthur, and he's making an assumption here. I'm not sure if the facts are in evidence, but let's just go with what he says. We have seen a significant increase in private firearm ownership and concealed carry of weapons permits. Mr. Arthur then says the likely outcome of this is an increase in shootings with claims of self-defense. How do you plan on handling shootings in which self-defense is claimed? And how do we keep Chicago from becoming the Wild West of shootouts?
Okay. Well, let me at least minimally address the assumptions that there's been an increase of ownership of private weapons. I don't have any facts on that, but I'm going to say that just from stories that I've read, that may be true, where you see gun store owners interviewed, and they're talking about having seen more customers and buyers than they'd seen in the recent past. It's apocryphal, but I'll go with that assumption. As for concealed carry permits increasing, again, I don't know that, nor have I seen statistics, but if there's increased ownership, and hopefully if people are buying guns, they're obeying the law and getting the kinds of firearm owner identification requirements that are out there and have to be have to be followed. And if they want to carry a weapon where they have a firearm owner's identification card, if they're going to carry it concealed in the public outside their home or business, I would hope, and obviously they're going to be in violation of the law if they don't get a concealed carry kind of permit. So I'm going to assume, without having, I guess, specific knowledge as to both the increase of the ownership and increase in concealed carry, because I think the question is an important question. I don't know that I've looked and seen in the papers or those various kinds of Chicago Police Department where they do their annual number of, the kind of crimes are being committed, the kind of defenses raised. I don't even know if they list the kind of defenses raised. But certainly when you have more firearms out in the public, and even legal, which is what this question is based on, how are you going to separate where there's a shooting to determine whether it is self-defense, which is justified, or if it's one of the homicide offenses not justified, such as an intentional homicide first degree, or a belief that you have self-defense and you're wrong, which is a second degree, or if you have a situation where there's a reckless use of a weapon, which is an involuntary homicide. And it's always factual. When you have a homicide, your best witness is missing. Whoever it is that is the victim, obviously could have given information as to the circumstances in which the shooting occurs. They are gone. And that's just the given on a homicide. Now, what you're left with sometimes is just the kind of statement or version of the person who has fired the gun. It can be a difficult case. Now you're looking circumstantially for the kinds of things you're always looking for in a homicide case. Is there a report and by the person who is the shooter as quickly as possible to the authorities? Does the person remain on the scene? Do they surrender the weapon? When you're trying to do a reconstruction, if it's shell casings, where are the shell casings relative to the person who is shot, relative to where the person who is the shooter says they were in relation to the victim? How many feet are they from him? How real is self-defense when you're 100 feet away? When you're 3, 4, 5 feet away, or more a shorter distance, you take that into account. So it's like everything else, crime reconstruction, which prosecutors should be aware of and they should be trained in. And when you do enough cases, you certainly get that training from the very detectives who have been trained and are trying to bring you cases and obviously tell you their version of how they reconstruct. That's the critical thing. So it's training from the assistants. It's hopefully the police, and I detectives in Chicago Police Department, and I've worked with FBI, state police, county police, local police in other counties. And I found that overall, the Chicago Police Department detectives are the best trained because they're trained by other detectives who have an incredible amount of experience, and they get an incredible amount of experience. So it's not necessarily that they come to the situation with with higher IQs or better instincts. They just get better training. So I think we'll be able to separate the kinds of shootings that fall into a category where someone needs to be charged versus the kind of category where someone obviously has a justifiable claim. And quite frankly, it's something that's confronting us. As I assumed the start of your question, it may be the case. I just haven't seen an incredible number of cases where self-defense is claimed. But you've got to be ready for them, and you've got to be able, through training and through experience, to make that decision. And that's a decision that the state's attorney and state's attorney's office will have to make.
Thank you very much. Frank Patton of the club asks, Judge O'Brien, what is your position on protests that turn violent and do damage to property or actually injure individuals? He says, like what happened at Northwestern last weekend, or like we saw in downtown Chicago, where I can point out my office is on Michigan Avenue, and back in May or June, I guess it was, building 3 doors down was torched in the midst of one of the riots. Should those, what, Frank Patton asks, what is your position on such protests?
Okay. Well, I appreciate the question because obviously we've seen not just the Northwestern criminal damage to property of their iconic gateway, but 2 full-scale, I guess, civil disturbances in Chicago in this past year alone. And I don't think you can be comfortable in the belief that something like this will not happen again. So I'm going to address the question this way. First Amendment rights to protest will always be guaranteed. They are essential both to the Constitution and I think to the ability for this country to function, because protests which are lawful and which point out problems, a lot of times those problems are real, and the only way that you can get elected officials to address them is by having lawful protests. Because after all, elections occur on a either 2-year basis or 4-year basis or 6-year basis in the case of senators. So you don't always have the ability to change representatives at the election box. So the idea that you can, kind of give some impetus to either legislative changes, to policy changes through protests seems to me essential, not just to this country's success, but to our ability to adapt, which has always got to be done. Then the question of what happens, and I don't know that the protests necessarily devolve or change into illegal behavior. It's at times that a protest may be ongoing and very lawful and obey every rule that you could think about, but there are people who have different intentions in mind and take advantage of the fact that the police, while protecting First Amendment rights, don't have enough officers or places that, or iconic structures might be the subject of criminal damage to property, looting, burglary. So those have to be addressed. And part of the problem I have with Kim Foxx is that maybe you could not have anticipated the first day and that first set of looting that occurred in Chicago would have been that last weekend in May. But after the first night, when it was going to continue for 2 or 3 other days, she had the responsibility as the chief law enforcement officer to get on the media and directly address this situation and tell people, if you loot, if you riot, if you commit property destruction, if you injure people, third parties or first responders, that is going to be, you're going to be arrested and you're going to be prosecuted. No ifs, ands, or buts. So you've got to basically make sure that people that are uncertain now know that there are consequences. Okay? Now, and as to how you then handle it, you've got to be ready for, I guess, more than just an individual arrest. You've got to be ready to address mass arrests. When people are walking in and out of broken glass windows to loot stores of their merchandise, where vehicles are being double parked in the street on Oak Street or Michigan Avenue in order to basically clear out stores. That's the kind of thing that's got to be addressed and addressed with, I think, the appropriate enforcement of the law. You just can't sit back. the victims of crime shouldn't have to pay for the criminal's acts because the state's attorney doesn't want to enforce the law. It's got to be enforced. Looting, burglaries, criminal damage to property, all of that has to be effectively addressed. And it doesn't mean that everybody has to, go to jail at the end of this particular process. You can again look at and address what's the background of the person, what's the kind of crime they're charged with, are they part of some, upper level in the organization to bring this thing about, or are they just somebody who fell into this? But it's got to be addressed. First Amendment rights protected, criminal violations addressed.
Judge O'Brien, you are apparently a lifelong Democrat, and by your original opening statement, you became upset with things that were going on in the state's attorney's office and essentially decided to come out of retirement. Rather than run in the Democratic primary, ran in the Republican, on the Republican line, and you won a primary there. I want to ask you about as nearly a lifelong Cook County resident, I want to ask you about the institutions of government, the institutions with which you will be relating on a day-to-day basis should you succeed in your campaign. So for instance, just a couple of days ago, I think Toni Preckwinkle announced that she's thinking of $700 million in new taxes for Cook County. We had a situation maybe 5 years ago in which there was almost open warfare between Chief Judge Tim Evans, Sheriff Tom Dart, the then state's attorney, and Toni Preckwinkle, etc. You've been on the inside, you've been in the belly of the beast, so to speak, the big structure of county government for much, not all, but much of your professional career. And I wonder if you can take this opportunity as a candidate to talk about its weaknesses, its strengths, its service to its taxpayers, and what you think needs to be done to improve Cook County government. At least I'm not asking you about the hospital. I'm not going to ask you about mental health. I'm just asking you about in the provision of justice, civilly and criminally, what can be done to improve Cook County and its organs and institutions in their delivery for the taxpayers?
Okay. Fairly complicated question. I hope I can give at least an adequate answer. There are, people talk about key players or major players. You've got the county board with Ms. Preckwinkle as the chief, and obviously that's where the money comes from that funds the sheriff's office, the chief judge's office, prosecutor's office, public defender's office. So you're really then talking about budget issues. And obviously the sheriff is responsible not just for unincorporated Cook County, but as I said, the sheriff is watching over not only people in jail, but also people whose activity level and freedoms are restricted because of bond and because of electronic monitoring. State's Attorney's Office has a responsibility to prosecute and to charge. It seems to me that not everything can be determined by money. I think the State's Attorney's Office, even at the level that it is, and it's been reduced in personnel by maybe 140 or 150 assistant state's attorneys, I think it can still function effectively. I'm hoping, and I read in the paper on the Preckwinkle budget, that at this point, at least, it didn't call for a reduction in positions in the office. But I do think the sheriff's office has got to get additional funds so that, as I said, global positioning monitors can be part of the electronic monitoring system. I think that, the county budget it only has so much that you can squeeze from the persons who are living here. And I think it's got to be understood that the safety of the community, the belief that Chicago and Cook County are places where you can go about, spend your money, visit museums and theaters and restaurants. That's got to be something that people feel you can do. In addition to the problems in housing, education, and jobs, criminal justice and the belief that the community is safe and that victims have a voice is that fourth, I guess, leg of this. And I think if the criminal justice system is adequately funded in each of its parts, that we're not going to see taxpayers who are, both from the county leaving here, from other parts of the state coming to visit and spending their money, from other states spending their money, from outside of the United States. So we've got to be funded, I think, as long as there are no additional cuts to the state's attorney's office, the funding level is appropriate. There could be federal grants. As I said, I want a witness relocation program instituted. And I love county money and state money to assist on that, but I think federal grant money is out there. And the sheriff's office has got to get more funding for GPS. Okay. So if we can do this and reverse the trend of trying to squeeze more money out of fewer taxpayers, we can get more taxpayers in, we can get more visitors and people who come to us and come to this county and city and basically, spend money, and that money, some of it ends up in the county coffers.
All right. I really appreciate your addressing that question and indeed all of these questions. Judge Pat O'Brien, what is your email, or I'm not your email, what's your website? Why don't you tell everybody where to go to see your web page and learn about your positions and maybe support your campaign?
Well, I appreciate that. It's o'brienforcook.com. I had to think. OBRIENFORCOOK.com. It shows you that I haven't been a politician very long.
Your Honor, it's a privilege to welcome you to the Union League Club. And when all this COVID craziness is over, we hope to be welcoming you in person. And I do want to say, I want to remind everybody, we've invited Kim Fox. She's accepted the invitation. She'll be here tomorrow. All are welcome. We look forward to hearing from her. We've already heard from Mark Curran, candidate for Senate. Senator Durbin is considering the invitation, and we hope to present him before the election. Judge O'Brien, we know win, lose, or draw, you're showing a major commitment to community and country, and we really appreciate your doing that. It's in the finest traditions of the Union League Club and indeed citizen action. So thank you very much for your commitment.
Chris, thank you very much. Members of the Union League Club, thank you also. And it's a privilege to be able to address you. Thank you.
And we also recognize the Standard Club for co-sponsoring today's event. Ladies and gentlemen, with that, we draw to a close. Thank you and have a lovely afternoon.
Thank you all.